Welcome to the Sierra Club meeting here in Endicott, New York on a nice snowy March 16th. And we're pleased to have Mary Jo Long speaking to us tonight. Mary Jo is an attorney from Afton, New York, and she specializes in workers' compensation. She knows firsthand about dealing with corporate practices that injure the environment and injure people. So she will take us through an explanation and a little history tonight, I believe, on how this corporate world came to be and how it is affecting the environment we live in today. And I turn the rest of the meeting over to Mary Jo. We welcome you.
Thank you.
Please tell us what you need to tell us.
All right. Okay. I think I'm going to start off by saying what my T-shirt says, because I've been looking for an opportunity to wear this T-shirt at an appropriate event, and today is the event. It says that slavery is the legal fiction that a person is property, and corporate personhood is the legal fiction that property is a person. Trying to juxtapose that notion of personhood. When I taught, many years ago, I taught a course on women in the law, and doing research, I was fascinated and disturbed to learn that women were not considered persons. That term has a very legal, important legal meaning in the law in both England and the United States for most of the first century and a half that this country existed. It's very strange, but for example, Susan B. Anthony was prosecuted for trying to vote, and the voting law that she was prosecuted under said anyone who was a person who was born in the United States was a citizen and therefore could vote, but she was prosecuted and the court found that she was not a person within the meaning of the law, the 14th Amendment at the time. So this notion of being a person is very important. And as you can see, the notion of who a person is often different than what our common sense would tell us. And it has had great legal significance in terms of corporate law and corporate history. I'm going to back up a little bit and talk about corporations in this country. When we gained our independence from England and fought the Revolutionary War to do that, part of the resistance to the rule of the British government involved resistance to corporate governance. New York State was founded by the Dutch East India Company, which was a corporation created in the Netherlands to exploit a particular geographic area. It was given this geographic area. It ruled the area that eventually became New York State. The Carolinas and I think Virginia were also at one point ruled by British corporations. The British East India Company had a monopoly on tea that the British government had given, the Crown, the English Crown had given to that company. And the Boston Tea Party was not just a resistance to British rule, but in fact also a resistance to the corporation that the British government had given a monopoly to. So when the American Revolution happened, the Europeans, people who created the United States, were very concerned about the abuses and powers of corporations. They had experienced it. And so, as the Constitution was formed, first of all, the Constitution of the United States does not have the word corporation in it. And many powers were left to the states. And one of the powers that was left to the states at the creation of our political system was the power to create corporations. Corporations are artificial entities, legal fictions. And it continues in this country that corporations are chartered in a state. So for example, I think it's probably Delaware has the most corporations who are now chartered in their state. But New York also has a charter law. And in order to exist, a corporation has to be issued a charter. And that charter will give a corporate purpose. And in the beginning of our country, the legislatures and the people were very restrictive in what they allowed corporations to do. First of all, corporations were only allowed to be created for purposes that helped the public. And they were often given limited time frames within which to accomplish that purpose. So to create the Erie Canal, a corporation was allowed to be created to do that. And investors could collect their assets to do this project that would assist the public, it was felt. And their investments were somewhat protected in that if a worker was injured or something happened that was going to result in a lawsuit, the corporation was the one that was liable, and the stockholders, the owners of that corporation, were not as, their other assets would be protected. Now, when corporations were first allowed to be chartered in all of the states of this country, they not only limited the number of years that the corporation could exist, but they also limited things like a corporation was not allowed to own any other corporation. A corporation wasn't allowed to own real estate or property except that real estate that directly followed through on the purpose that the corporation was made for. Now, and one of the reasons, there were reasons, of course, that the citizenry, the people, were concerned about corporate abuse. They had experienced it in the American Revolution, and they saw it as a way that wealth could be amassed, and with that amassing of great wealth, that wealth could control property, could buy the newspapers and control the information that the public got, and could affect elections and all kinds of trade. Does that sound familiar? That's what we have now. So this was a concern from the very beginning of our country. Anyway, corporations were very controlled, but as history tells us, the times did change. Lawyers, and I'm a lawyer, but lawyers who were representing corporations tended to develop arguments, and one of the arguments that was developed after the Civil War, by and large, was that corporations should be persons as they are treated in the Constitution. And what that meant was corporations were already being treated as artificial persons, so they were able to sue and be sued, even though they were limited in the number of years they could exist, and they couldn't buy other corporations and things of that sort. But they did have access to the courts. And so the lawyers for various corporations began to systematically argue that the corporation is a person as the term is used in the U.S. Constitution. And sort of the most important use of the word person in the U.S. Constitution is found in the 14th Amendment. The Constitution was originally sort of a body that created the three different branches of government, and the first 10 amendments were added right after the Constitution was adopted, and those amendments were to give people certain basic civil rights, because the main body of the Constitution didn't really do that. It defined government, it set up the judiciary and the legislature and the executive, but it didn't really define any rights of people. So those first 10 amendments were called the Bill of Rights, and we're going to talk a little bit more about them in a minute. But the corporate lawyers began to argue specifically that the 14th Amendment should give them rights, them being the corporations, because the 14th Amendment says any person, born or naturalized, and subject to the jurisdiction of the United States, has certain rights, is entitled to the equal protection of the law, the privileges and immunities of citizenship, and due process of law. And that amendment was passed after the Civil War to guarantee former slaves certain rights, because the southern states in particular, but even to some extent in the north, other states, were treating former slaves and African Americans differently. And so the 14th Amendment was passed to give black people equal rights. But the term, it doesn't say we want to give black people equal rights. It says any person born or naturalized. So the word person becomes very central. The lawyers argued, and of course lawyers then sometimes become judges. And so many of the judges who had been corporate lawyers began to interpret the Constitution. And several Supreme Court cases had argued that lawyers had argued cases in front of the Supreme Court saying the corporation is a person. And finally, in 1886, the Chief Justice of the Supreme Court, Chief Justice Waite, announced at the beginning of the oral argument in a case called Santa Clara versus Southern California Railroad Company, announced that that a corporation was a person, and they didn't want to hear any argument about it, or didn't want the two parties to brief, that is, to write legal memorandums arguing the various points. And from that day in 1886, the corporation has been treated as a person who is entitled to certain rights under our U.S. Constitution. Okay? Now, every once in a while in a Supreme Court decision, some justice will complain about this and say it really wasn't done properly, but it has been mostly accepted. And so it's a sea in which especially lawyers, but really all of us swim in, the notion that corporations kind of, well, they just have all the rights that everyone else has. Okay. But it has been, in fact, a very systematic legal strategy. And just because the Supreme Court has decided it doesn't mean they can't change their minds. And of course, the very best example of that is the same court with almost or maybe exactly the same identical members of that Supreme Court decided a case called Plessy versus Ferguson, which said black people can be kept separate and equal, and that does not violate our U.S. Constitution. And that case was finally overturned by the Supreme Court. They reversed themselves in 1954 in Brown versus Board of Education, at which point they said, no, separate but equal is never equal, and it does violate the U.S. Constitution. So that court can be reversed, as that court has been reversed in other cases. And it's a notion that is really quite novel in our present day and time, in this present world in which it seems to be beyond question that corporations have power that puts them ahead of people. And I'm going to talk about that in some very specific ways here. So anyway, corporations from 1886 on began to sort of claim various rights. I mean, that was the 14th Amendment right that they were given protection under the 14th Amendment. And another big one, of course, that corporations have claimed is First Amendment rights. You find that is the First Amendment is the right, in particular here, the right of free speech. So corporations have successfully argued, first of all, that they can't be limited in the campaign contributions they make on political referenda. First National Bank of Boston objected to a Massachusetts state law which said banks cannot contribute money to run campaign ads for political referenda. They took the state of Massachusetts to court. The Supreme Court ruled in favor of the First Bank of Boston. It's a corporation. It has First Amendment rights. Some of the First Amendment rights that corporations have claimed are called commercial free speech, but that's just one kind of free speech that they've claimed. In commercial free speech, for example, New York had a law during the 1970s when there was the energy crisis. New York passed a law saying public electric utility companies could not advertise to get people to use more electricity because we were having an energy crisis, right? You know? Well, the utility companies took New York to court, and the Supreme Court said, no, they have rights of commercial speech. We can promote products and sell them even if it's not in the interest of people, in not in their economic interests or their, there are other interests, but in this particular one it was an economic interest. One of the most interesting ones recently is, it was a case called Klasky versus Nike shoe company. Nike had been getting a lot of bad publicity about exploiting their workers in China. They have these sweatshops and exploit very young Chinese women workers, and had gotten a lot of bad publicity. So Nike started advertising, claiming that they were following certain sweatshop rules that were supposed to, and they were having improved working conditions in China. And a particular activist named Klasky checked it out, and they were lying. And so he took them to court in the state of California, and basically it was like a prosecution. An individual could bring a lawsuit under the truth in advertising provisions of the California law. Nike appealed. There was a decision sort of saying, yes, this is a valid claim. They hadn't done a trial yet. Appealed to the Supreme Court. And Nike claimed in their case that they had the right to make any claim they wanted, even if it was a lie. They claimed that they were protected, even in lying, in telling something that was, they literally argued the truth of it doesn't matter. We have the right to say it as our right, our First Amendment right of commercial free speech. That case was settled out of court. So we didn't get a decision on that one. And even there are rights of negative free speech. The examples there are public utilities did not want to put information in their bills about the Public Utilities Board, and there were lawsuits around that, and also one around Monsanto sued the state of Vermont because the state of Vermont passed a law saying they had to label all dairy products as to whether they had artificial bovine growth hormone in them, which is a genetically engineered product given to cows to make them produce more milk. And Monsanto, who produces this product, sued the state of Vermont, and they won using their right of sort of negative free speech. We should not be forced to give this information in this labeling law. This violates our First Amendment rights. This is a corporation talking. So that's the First Amendment. Corporations have also claimed successfully Fourth Amendment rights, and this is one that affects us a lot in terms of environmental concerns. The Fourth Amendment right is the right to be against unreasonable searches and seizures. And we, as human beings, the Fourth Amendment was one that revolutionary Americans were very intense in their insistence on some sort of protection because, in terms of privacy in their homes, because British troops had been housed in their homes and sort of helped themselves and could just barge in and look around and had sort of no limitations on the right of the police or the military to go into homes and ransack and look for whatever they wanted. So the Fourth Amendment prohibits that unless you have a warrant. Now corporations have successfully claimed the Fourth Amendment right so that the Occupational Safety and Health Administration, the Environmental Protection Agencies, DEC, which is the state equivalent in Department of Environmental Conservation, cannot do random inspections or searches in factories. They have to get a judge to issue a warrant. And of course, by doing that, that gives the corporate lawyers an opportunity to fight that warrant and to try to convince that judge that the warrant should not be issued. And so it has resulted in hamstringing and hampering some of the agencies that really have as their purpose to protect our health and our workplaces. And yet corporations are claiming these rights of people to not have to show what they have. And I could spend a lot of time talking about it, but I want to kind of get onto some other stuff. But if you have questions, I'll gladly try to answer them. Anyway, the corporations have also claimed the Fifth Amendment right against self-incrimination and double jeopardy. They can't be forced to testify against themselves. Of course, it's sort of hard for a corporation to testify against itself because it's an artificial entity. But they succeed by using their corporate executives as sort of the spokesperson, the human manifestation of their personhood. Sixth Amendment rights, which is the certain rights in terms of jury trial and defense, ability to have counsel. And I mentioned already the 14th Amendment. There was an interesting 14th Amendment case recently about cell towers. Several local communities have engaged in scientific research and concluded that cell towers in the center of communities might have some serious negative health effects. But the Telecommunications Act of, I can't remember what year, the federal government declared that states couldn't ban cell phone towers and the location of them for health reasons. They specifically said, you can't do that. And yet the communities tried, and they've gone to court, and the courts have upheld the corporations, the cell phone corporations' rights to site the cell phone towers in communities where the citizenry, the people, have in fact voted and said they don't want cell phone towers in the center of their community. They passed zoning laws to keep it a certain distance from the center of the community. Those lawsuits were won by the corporations who are putting up the cell phone towers. So there really is a sense in which the corporations haven't just put themselves on an equal footing with people having the same rights as real people, but they've literally come to really have more influence and more rights than us, than the people who are supposed to be protected by the Bill of Rights and the other rights in the Constitution. One of the ways that they've done that is through affecting the legislature. I mentioned, for example, Congress passed a law taking away the right of communities to make a determination that for health reasons they don't want cell phone towers. And that's because the legislature, the Congress, was the beneficiary of significant campaign contributions and the influence of lobbyists who promoted the cell phone towers. And of course, that's only one of many, many, many examples. The Congress has recently passed laws. They've limited the liability of nuclear power plants, which are owned by corporations. They have tried, it's just been in the news just within the last week or two, to pass a law that limited the liability of gun manufacturers because lawyers are beginning to try to say, hey, wait a minute, the manufacturer of these guns do have some responsibility for the gun violence in this country. And Congress tried to pass a law. It actually got taken out of the I think it was a budget bill that just passed recently. But it has shown up, and it probably will show up again, is what I hear on the news. Methanex Corporation has been in the news a lot. They got their a little piece of limited liability for themselves. They manufacture gasoline additive that pollutes groundwater. And it was initially banned in the state of California. New York has now actually passed a law banning it too. But the U.S. Congress had a provision in their energy bill that the Methanex in fact, not just Methanex, but all of the manufacturers of this additive that pollutes groundwater would have limited liability. So that, I mean, we human beings, like, if one of us were responsible for polluting groundwater the way IBM has done, individuals are liable for that. They can be sued, their property can be taken, all of their property can be taken up to the limit where you're judgment proof. They won't put you in prison if you can't pay a debt, but they can take your property. And yet corporations claiming rights of personhood to be treated like us have in fact stepped to the front of the line and get extra privileges that we real human beings don't get anymore. So these, we hear about them quite often, the various bills passed which limit liability. That's a service to large corporations. And perhaps I should just distinguish between, I'm really emphasizing the very large corporations. I mean, there are small corporations that do, that are in their local community, a family business, a store, a restaurant, something that's happening locally. Those really are very closely run by individual people and tend to be much more responsible because they live in that community. The large corporations that are giving us so much polluting and contributing so much to the environmental problems of this country are not organized that way. We know that they have, they have large numbers of stockholders, but many proxies are held by the corporate executive officers and by friends and cronies who give them enormous salaries and who really must run the corporation with the notion of maximizing their profits. The notion of a corporate purpose, which exists in charters, the charter that creates a corporation, has become almost meaningless. Most corporations now are incorporated with the purpose of making money, whatever the endeavor or enterprise may be. The purpose of the corporation is to make profit for their shareholders, for their corporate executives. And so the concern with the public interest is thrown out the door. And in fact, if you had a corporate executive who really wanted to do good things, if that interferes with profit, that corporate executive would be replaced because the stockholders, the shareholders, and the board of directors would insist, and does insist, that a corporation maximizes profit. And the last way that corporations have really stepped in front, to the front of the line, in front of people, is through trade agreements. And I won't spend a lot of time talking about it, but I'm sure all of you have heard of NAFTA, the North American Free Trade Agreement, the World Trade Organization, WTO, and there is a new trade agreement being negotiated called the Free Trade of the Americas Agreement, which would expand NAFTA to all of South America, as well as what NAFTA now applies to the United States, Mexico, and Canada. Thank you.
The cat water.
Say what?
And the cat water.
And the cat water. Well, got to do what you got to do. Thank you. Anyway, I don't want to spend a lot of time talking about trade agreements because that's a whole lengthy topic, but really the trade agreements are, so-called free trade agreements, are agreements that protect very large corporations who trade on a global level in ways that prevent local communities, local governments, it prevents local governments from regulating corporations, is really what it does. And there are several efforts. California, when it passed this law banning Methanex, or the additive. The Methanex Corporation, which was a Canadian corporation, sued them, not in our courts and not in the Canadian courts, but in a NAFTA court, which is, you can't appeal to the Supreme Court. You can't overrule a NAFTA court. It's a bureaucratic court created just in that trade treaty. And they claimed the right that the state of California would have to pay Methanex Corporation all of its future lost profits from having its product banned in the state of California. That's taking away the right, the elected government of California, or the elected government, and so far the corporations have not been able to actually go to the polls and push down that little lever. We, the people, still have the right to vote, and the corporations do not yet have the right to vote, although of course they can influence it through their money. There really are a number of different things that I would at least bring to your attention, and I'm sure that you probably have some ideas and suggestions too. One is to stop assuming that corporations have all these rights and that they are going to keep all these rights for the rest of time. In the same way that the Supreme Court declared that separate and equal was fine and consistent with the Constitution, but there was a movement of people to claim what we all knew was fair and right and just at a point when the civil rights movement started happening. And the court changed its mind, not out of its goodwill, but because there was a movement and there was a demand. And our government responded to that demand of people to have equal protection and civil rights for people of a different color than the majority white. So in similar ways, people can demand, and if there is enough demand, the courts will respond to the notion of bringing our corporations back under our control. And one of the interesting ways that I learned about how we can do that came about because I ran for Attorney General of New York State as the Green Party candidate in the year 2000. And so one of the things I found that the Attorney General of the state of New York and other states as well can do, under New York State Business Corporation Law, Section 1101, the Attorney General may bring an action to dissolve a corporation. So corporations live forever now, right? They don't have 4-year limits or 30-year limits. That has kind of fallen by the wayside, but of course it could happen again. But corporations, if allowed to go on, can exist forever. So they never die, they never pay death tax, inheritance taxes, they live forever. But there is literally, in essence, a provision in the New York Business Corporation Law for the death penalty for corporations. And that penalty is imposed if the corporation has exceeded its authority or violated any provision of law whereby it has forfeited its charter, or carried on, conducted, or transacted its business in a persistently fraudulent or illegal manner, or finally by the abuse of its powers contrary to the public policy of the state. Now, those are very broad. The abuse of its power contrary to the public policy of the state. Now, is it the public policy of the state to protect the health and protect the health of humans, the New York people who live in New York and its land? Yes, that is the public policy. We have environmental conservation laws in the state of New York. We have criminal laws to protect people from unsafe persons. And so right there, you could do it. Or there's a provision, carried on, conducts, or transacted business in a persistently fraudulent or illegal manner. General Electric Corporation, incorporated in the state of New York, is a convicted felon they have been found guilty of felonies. You can't go to jail if you're a corporation, though, can you? Sometimes you pay a fine. But General Electric Corporation, a convicted felon, is allowed to own another corporation, the NBC Broadcasting Company. It is allowed to own that other corporation, which uses the public airwaves and dispenses information that affects the profitability of the General Electric Corporation. General Electric Corporation is one of the largest nuclear weapons manufacturers in the world. Do you think that the news that goes out on NBC is going to interfere with the profits of a convicted felon like the General Electric Corporation? Maybe the Attorney General of the state of New York might be interested in challenging in dissolving the corporate charter of the General Electric Corporation. Now, that would be a very interesting lawsuit, wouldn't it? And, we would have to get past judges who might have been corporate lawyers, who might have been GE corporate lawyers. But it can be done. And there are places in the United States where those things are being challenged. In California, there is a challenge against Unical, which is United Oil Company of California. Unical is sort of famous. They're the ones who were wanting to put a pipeline through Afghanistan, and the Taliban refused to let a pipeline go from Uzbekistan through Afghanistan down to the port to an oil pipeline. And Hamid Karzai, who is the present, I don't know if he's called prime minister or president, but he's the sort of head of the provisional Afghan government, which is occupied by the U.S. Army. Hamid Karzai worked for Unical, and those plans for that pipeline are now being resumed. But it also has a very sort of ugly corporate history about some other things, but that's Unical. And their corporate charter is being challenged in California. Even in New York, Dennis Vaco, who was the Attorney General before Eliot Spitzer, did bring an action under this business corporation law to revoke the corporate charter of the Tobacco Institute, which was a fully owned subsidiary of the tobacco companies. And he brought up an action under that provision of the law that I just cited to revoke the charter. And out of the mass settlement of the tobacco lawsuits, that corporation voluntarily agreed to dissolve, and the assets were given to some organizations who were doing anti-tobacco education, and the records were given to a public library. So anyway, we could start being a little more proactive about making corporations follow the law, and if they are persistently violating the law, they should be dissolved. They should have the death penalty. 3 strikes and you're out, right? We can withdraw from these trade agreements that place corporations above the laws passed by our duly elected democratic, little d democratic system. And some of the individuals who have been campaigning for president have raised those issues, not very many of them, but there's been a very, very positive response on behalf of a lot of people. And so if we had candidates running for office who articulated those issues, I think although NBC, ABC, and CBS might not like it because those are multinational corporations owned by other corporations who like these trade agreements, but the people are very supportive and understand how these trade agreements are not helping deal with the labor needs and the environmental needs of the people. Finally, I would say we need to support and grow citizens groups who are trying to resist some of the corporate abuses that have occurred. And this is not a political, you can't endorse candidates or anything like that, but I would also say look at your political parties and support candidates who stand for these issues also. And there are some interesting organizations who are doing a lot of this kind of work, and I have a little handout that I thought if anyone's interested in knowing more about some of these things, I can give you some websites to look at and some information that you might want to, if you might want to learn a little bit more. In particular, there's an organization called POCLAD, which is the Program on Law and on Corporations, Law, and Democracy. And they have some very interesting, they do a lot of historical work into this whole notion of corporate personhood and how, it is not what the Constitution meant, and it does not have to continue to be as it has been interpreted recently. And a group called the Community Environmental Legal Defense Fund, which is located in Pennsylvania but has represented many citizens groups in their efforts to claim democratic rights for environmental concerns, even though corporations are resisting it. They've done one of them is hog farms. Some communities in the state of Pennsylvania banned corporate hog farms, which are very messy, very smelly, cause all kinds of pollution problems. And so the communities, the township governments have passed laws prohibiting them in their townships. And so these corporations have sued the township to, claiming personhood rights, 14th Amendment rights, and those cases are being litigated. But really while we may not win those lawsuits, or maybe not win all of them, they do begin that dialogue and that educating of people that, wait a minute, how come the corporations get these rights of profits even when it's not in the environmental or economic interest of real people? We need to put real people back at the front of the line instead of at the back of the bus. And there are organizations out there that are trying to work for it, and I think even here in Endicott, in terms of IBM, there are organizations that are trying to at least figure out the most effective way to deal with the environmental effects of corporations who minimize the environmental cost that they would have to pay out of their pocket, but that they could maximize their profits. Now, the announcement for this meeting said that I would talk about IBM, and I'm not the knowledgeable person about IBM here, but I would like to sort of point out a couple of things that I think are relevant about IBM, relevant to what I've been saying about corporations. First of all, I would say that we should not expect that a big corporation such as IBM to respond to the particular human concerns of real people. Just as I said earlier, that corporate executive officers are accountable to their board and their shareholders. And their duty, their responsibility is to maximize their profits. I mean, Michael Eisner in the Disney Corporation was removed from one of his offices because his corporation isn't making as much money. The bottom line for corporate entities is they have to maximize their profits. And they will do that to the detriment of our environment and the working conditions to the extent that they can get away with it. So my sense is that IBM has always touted itself as a benevolent, paternalistic corporation. We're going to, take care of, we're a good citizen, and we do what's right. And I think that you can't believe them. That if you operate on that basis, they can agree to voluntary monitoring, and as soon as it's they don't want to do it anymore because of publicity or has passed or whatever, that voluntary monitoring will stop. And people have to claim their rights as real rights, not hope for the benevolent and voluntary goodwill of big corporations. And I mean, I'd love to, I hope that maybe some in the audience might want to talk about what's happening there. I know that, there's a lot of venting of vents being installed in homes and buildings around Endicott by IBM, but that's a minimal, they're minimizing what they have to spend money on. And I just think that we should not rely on the kindness and altruistic motives of such a large corporation. And the other thing, of course, is a lesson that pertains not just to IBM, but sort of all corporations, is that the regulation of these large corporations has been largely unsuccessful. When this whole notion of corporate personhood became accepted after about 1886, I mean, it wasn't accepted immediately, but cases continued, and they added the First Amendment and the Fifth Amendment and the Fourth Amendment to their rights. I mean, it happened over a number of years in legal strategy into the 20th century even. The solution to the problems of corporate abuse, instead of cutting them off at 30 years and not allowing them to own another corporation or do these other things, the solution that was touted to the problems that these corporations created was to regulate them. So you create a Interstate Commerce Commission, you create an Occupational Safety and Health Administration. You create these various agencies to regulate these companies. The Environmental Protection Agency, the Food and Drug Administration, all of these government agencies are to regulate big corporations, to try to ameliorate the damages that they do in their drive for corporate profit. I mean, they're not a human being. They don't have a heart. They're a bit like a Frankenstein monster. They've been created by humans, and they've taken on a life of their own that in fact controls humans, even the corporate executives who are sort of supposedly running them, because those corporate executives can be replaced if they don't make their profits. So the regulatory agencies have been almost uniformly unsuccessful, and regulating them has largely become too expensive. So over the last 25, 30 years, meat inspection at the U.S. Department of Agriculture, inspecting the, meat is now, I think there are 4 beef and meat companies who control 80% of all beef sold in this country. 4 corporations. And I think with poultry it's 3 corporations. And Purdue bought BP, so now that's 1 corporation. I mean, the numbers it's so concentrated. And the U.S. Department of Agriculture, who's supposed to inspect meat, has less than half the number of inspectors that they used to have. So the agencies aren't regulating them. The companies are supposed to do self-reporting. Excuse me, that is not going to succeed in protecting human beings' health and safety or our environment. It is guaranteed to maximize those corporate profits at our expense. So, so the lesson, I guess, to get back to it, in terms of regulatory agencies, again, is don't rely on the regulatory agencies. It really is community organizing, which is the most effective way to get the attention, because then the government and the businesses will have to deal with people. If we deal with the lawsuits one at a time, there's always another one to deal with. And the lawsuits so far against IBM that I'm aware of, according to the paper, there are about 200 lawsuits pending right now against IBM with regard to pollution and also health effects on workers and birth defects on children of workers. There was a big lawsuit that was in Santa Clara County, California, that went to trial, 2 former workers with cancer. The jury came back and found for IBM. IBM won that lawsuit. Those lawsuits are very hard to win, and you do them one person at a time, or 2 or 3 people at a time. And there's just always another case of cancer, another case of birth defects, another case of pollution of public groundwater, another case of that. So kind of pursuing each offense one at a time is not going to get us very far. I mean, it may give us a little breathing room with respect to one particular problem and area, but it really does not solve the problem. And I go back to saying we have to be aggressive about it. We have to put pressure on the Attorney General to threaten dissolution, to begin to sort of try to get the federal government to respond on these issues in more serious ways. Remove the trade agreement protections. Fight them. Fight the corporations. I mean, we're not going to do away with all corporations because they do, in fact, sometimes provide, as in the beginning of this country, they were allowed to be created when they served a public purpose. And we need to get back to that notion that corporations should serve us. But in fact, we serve them. I mean, people are afraid to criticize IBM because they say, well, they'll leave the community and then we won't have jobs. And so we have to be their servants, and we have to be meek, and we have to be quiet, and we have to let them do their destruction. Well, there comes a point where you have to think about, is it worth it? Because they may leave that community anyway. I mean, we know here in the Binghamton area especially that that's a no-win game, because they get the concessions, they get the tax breaks and the credits and the Empire Zone special status, and then they don't hire more people and they leave. And they leave the public, mostly they leave the public holding the bill, because they convinced the government and the people that, we have to give them this money to finance EIT, being able to buy IBM's property to keep jobs, and then jobs leave, and the public is guaranteeing the loans. So if the loans aren't paid, I mean, we're the ones who, our tax money went to provide the money so that EIT could buy IBM's property. But we don't get to own it. We have to begin to challenge those notions. Everything that's good for corporations is not necessarily good for people. And what's important is that people should be in the front. Our rights should be the ones that we're most concerned about, not the corporation's rights. So anyway, that's the end of my spiel. I took quite a while. Any questions?
What knowledge do you have of the way that the Western European governments and their relationship with corporations? I spent some time over in Europe, primarily Hungary, but have been around Budapest and places like that. And the British corporations, German, French, they seem to have a much better control of their corporations. And I just wondered what knowledge you have of how they handle that.
That's a really good question, and I don't really know much about how the corporations have, how they've related to European governments as much. That would be interesting. If indeed they are more controlled, we might learn from their experiences. Yeah. That's very good. Yes, you had a question.
Yeah, I know you have some expertise in workers' compensation, and I think that most people don't realize that workers' compensation laws were established to protect corporations from lawsuits by employees, so that when a person is injured on the job, they are very, very limited in what kind of compensation they can get for their injuries. And I happen to know from experience, it's a very dirty business. But what about these situations where people were, like, a lot of it was talked about a month ago when Congressman Hinchy was here, and people were made very sick on the job by exposure to chemicals that they worked with at IBM. And I guess there are a number of people suing down in Poughkeepsie, for cancers and birth defects and so on. How are they suing with the limitations of the workers' comp laws?
It's a good question also. Yes. First of all, let me back up and say what you're saying about the impetus behind creating workers' compensation laws it certainly was partly to limit the liability of the employer. There were benefits also to the injured worker at the time, because before the workers' compensation laws existed, the employee, if he or she was injured on the job, they had to start a lawsuit. As you know, lawsuits take many years often, and if the employee, the worker, was in some way contributed to the injury, wasn't paying attention when the door slammed down and hurt his hand, there could be contributory negligence, and so they wouldn't get as much. So when the workers' comp laws were passed, they were supposed to balance off the larger, the worker gave up the larger amounts of money that they would get, because they would get pain and suffering as well as lost wages and medical costs. So they gave up some of those monetary benefits for supposedly a prompter payment of medical care and lost wages. But it very much protected the businesses and the corporations because they can't be sued for their negligent conduct in not fixing a dangerous situation. So, and that's what comp laws do. The question then that you had is, well, how can these companies get sued at all? As we're hearing, there's like 200 lawsuits around the country against IBM. One way is, of course, the lawsuit that was supposed to start in the beginning of March, and I haven't actually seen it. It was supposed to start March 2nd, and I haven't seen in the paper if it really did. This was down in the Hudson Valley, I think Poughkeepsie or Armonk, was for birth defects of the children of employees. So the workers' compensation laws don't apply to the children of the workers. It only applies to the worker. And so those lawsuits can go more broadly. The lawsuit in California, it may be that the comp law is a little different in that state, because compensation law is different from state to state. Each state has its own workers' compensation law. But if you take, if the chemical cases in New York workers' compensation law are very difficult. You have to show what chemical actually caused the damage. You have to have scientists and doctors testifying as experts, and of course the corporation always comes up with their experts too, and which expert is the judge going to believe? And so those chemical cases are very, very difficult, even though, we know that there are some impacts. And the problem is that many of the chemical cases are not adequately studied. Who's going to study them? The corporations don't want to study these things. They don't want to produce information that then could be used against them to show that they knew or should have known of the bad effects of the chemicals they were using. The workers generally don't have the revenue, the money to finance such studies. Those studies are very expensive. The government isn't doing it. They should, but they're not. public isn't demanding it. When the public has demanded certain studies, there have been studies. I think, as an example, I would say on Long Island, there was an organization formed called 1 in 9, because 1 in 9 women in Long Island had breast cancer, and now actually it's 1 in 8, but they kept the name of the organization as 1 in 9. And they demanded certain studies because they were concerned about the lawn chemicals and various chemicals that they felt were likely contributors to the very high incidence of breast cancer in Long Island. And because of their political demands, the government has responded with studies. And I think that we need to demand that the government conduct studies in order to begin to really get scientific information that informs us as workers and as communities and as the public.
Because I'm not sure we need more laws as much as we got to push these organizations. And I know Hinchy pushed the DEC here in Endicott to respond to the local spill. But your comments on that?
Well, first of all, there's a revolving door between government officials in these agencies and the corporations which they regulate. The U.S. Department of Agriculture, which regulates the beef industry, mad cow disease has been a concern. The U.S. Department of Agriculture really is the governmental agency responsible for regulating and testing meat in this country. Ann Veneman, who is the head of the U.S. Department of Agriculture now, before she was in that position, that regulatory agency, she worked for a genetic engineering company. And the two people immediately under her are former executives in the Cattlemen's Beef Association. I might have the name a little wrong, but and so they will return to their corporate jobs at some point after serving a stint in a regulatory agency, and that's true in almost all of the agencies. I'm particularly aware of it in terms of food because I'm active around organic farming issues, and it's a revolving door. Corporate people who are regulated by the agency then are put into positions by the president of the United States, the executive the executive branch of the government is the one who fills the top echelons of those agencies. And when people lower in the agency try to enforce the law in the way that it's supposed to be, they meet resistance at the top level of those agencies. And of course, the best example of that is that the Environmental Protection Agency had records and test results and knew that it was not safe for people to be working around the World Trade Center in the weeks right after September 11th. The air was full of asbestos, and they knew it, they had tests, and yet they were concerned about getting Wall Street back up and running. They didn't want the stock exchange to be down for long. And so despite what they knew, they, the lower level of at least the story that I hear is that the lower level employees in the EPA said, this is not safe, the test results show we shouldn't be letting people back in there. But further up in the chain of command, the political decision was made that it was more important to get that stock market back open and get people back there acting as if it was normal, regardless of the long-term health effects. So I think, my sense is one of the biggest reasons that the regulatory agencies don't work is, there's this political pressure that affects them, and the people at the top of those agencies are all political appointees, and they enforce their own agenda, their own ideology, the pro-corporate, big government, big corporation benefits from having their people in those positions. And I mean, those are two of the reasons. You know, it's, again, the regulatory agencies also take these issues one at a time. You know, OSHA goes in and cites one particular company as violating, or one particular violation that IBM does. You know, I mean, instead of going, you know, looking at the whole history, they try to enforce one issue or one violation at a time. And there's just too many corporations doing too much, and there's not enough money and time and people in these agencies to be there all the time. I mean, all these rights that they've gotten, like I said, and, you know, these companies now claim Fourth Amendment rights. You cannot do spot inspections. When I was a college student, I worked at a Kraft Foods company. We always knew when the government inspector was going to come in. Now, how did we know that? Our foreman would come around and say, now, the inspector's going to come around today. Be sure you got your hairnet on, because it was cheese and the women had to wear hairnets. I mean, we always knew. That was 30 years ago. It's more than 30 years ago. It was a long time ago. There's just too much cooperation between, you know, the government agencies and the businesses that they're supposed to be regulating. I mean, we hear it all the time in the news. So as I was driving here today, the EPA, what was it there? Mercury poisoning. The EPA did these studies of the coal-burning power plants and how much it's 80% of all American women have mercury, so much mercury in their blood that it is dangerous for the children of these women. And yet the EPA has decided
Raise the level of what's dangerous?
to not require the equipment that would reduce the mercury level to the level that the EPA has set. And there was, I mean, it was a political decision. They were discussing it on the radio tonight as I was driving here. Yeah. It would interfere with the coal-burning power plant's profits. So, and they said the technology has been developed and it's affordable, but they don't want to do it.
One of the issues here in Endicott is that no one knows, OSHA doesn't know, the amount of TCE exposure that is really dangerous. And there are all these OSHA standards. Mercury you just mentioned. They know what a small dose is, and they know what a lethal dose is, but they don't know what a dose is applied over years and years.
Well, also, those standards of doses are manipulated at times. I remember when, it was about 5 years ago, people who lived along the ocean in Long Island and New Jersey were getting very upset because medical waste was getting washed up on the shore, you know, hypodermic needles and bags of hospital medical waste. And so that was upsetting a lot of people. So they changed the regulations and they allowed this stuff to be dumped on farmland. But a lot of that medical waste has heavy metals in it. So the EPA redefined how much heavy metals could be applied per acre before it was considered toxic, and they tripled the amount. Not because there were any scientific studies at all, but because politically they didn't want to be dumping it in the ocean because people were getting upset. There are more people living around oceans than around farmland, so they dump it on the farmland now. So OSHA standards in and of themselves are not even the mark of what is safe or not safe. Yeah. They change the rules anytime it's in the interests of powerful people, powerful corporations. And they're not doing those studies to find what's a minimal amount. TCEs are very very toxic chemical. I've heard scientists say that. I was telling you earlier, I once overheard two scientists talking outside of a workers' comp hearing saying that the most dangerous job, in their opinion, and they were scientists waiting to testify in a case, was dry cleaning because they worked with TCE.
And they've known that since the early 70s at least.
It was in the 70s that I heard these
Yeah.
scientists saying this.
Hello, it's good to see some brave souls are here that came out and came down through the weather here to see Mary Jo tonight and listen to what she has to say. I guess I'm just kind of a little fill-in here, but some of the subject matter she's talked about really hit home because they overlap what we're doing. First of all, my name is Alan Turnbull. Thank you very kindly. And I'm the founder of the RAGE organization, and RAGE stands for Resident Action Group of Endicott. That was started in the latter part of '02, and we became known as RAGE in July of '03. And we've had our share of notoriety over the last year and a half. And actually, there was an article in the New York Times yesterday that was published. But you mentioned OSHA. And one of the things that disturbs me a great deal is because these agencies can come out and say, quote, OSHA standards. We're not sure how those standards came about, but they will quote them readily, and they'll say 5 parts per billion is okay for you, for your body, over an 8-hour working day. Now, Mary Jo, you're an intelligent person, you've gone to college, you've passed the bar, and I'm going to ask you a very simple question that probably I could ask a junior high school. If 5 parts per billion, whatever the 5 parts might be, are okay for you to breathe over an 8-hour working day period of time, and if you work a double shift, what does that do? Now, really, is it 5 parts per billion in 8 hours out of a 24-hour day so that your body has 16 hours to regurgitate or get rid of those 5 parts? What does that mean? Well, I can't get an answer. I can't get it from OSHA. I can't get it from a doctor. I can't get it from a lawyer. Well, that's the standards.
I know.
And it means nothing.
I know. I've had company lawyers, not particularly IBM necessarily, but employer lawyers in workers' compensation case argue, well, this individual worker, his workers' compensation claim should be dismissed because we met OSHA standards, which, you know, a 5 parts per billion or whatever that number is that they quote. And many times, first of all, that doesn't mean that the workers' comp case gets dismissed. The standard is not what OSHA decides. The standard in a workers' compensation case is, can the injured worker establish or prove that it's more likely than not that the exposure to a specific chemical caused the specific problem, whether it's 5 parts per billion or 1 part per billion or 500 parts per billion. It's a science, you usually need a doctor and you need to show that there was a specific exposure. So yeah, we argue these things in comp cases because it never fits so neatly as the OSHA regulation sets up. Person goes in and they're cleaning the facility, in the midnight to morning shift, and they're using a cocktail of chemicals. So it's not just the 5 parts per billion of one chemical, but there's the 5 other chemicals that they're using to clean the machines with, or an acid or an ammonia mixture. I mean, there are all sorts of other things that also affect people. And that OSHA standard is separating that out as if all other things are equal and safe. But we know in our world that you're maybe getting exposed to this particular chemical, but you're also being exposed to another one.
Well, of course, we can go
TCE
back.
wasn't the only chemical
Right.
that IBM used, right?
They used many chemicals, and they are still using many chemicals there, but they're not quite as toxic as they once were. There is a
You
safety
mean they've
factor.
outgassed?
Yes, they are changing them, and they have changed them for quite a while here. But nevertheless, the TCE and the PERC and all these names that the average person doesn't know what they mean are in the ground. They're in our groundwater, and quite frankly, the people. Is everybody here from Endicott? Everybody, or the Union, Town of Union?
Except me.
Because it's not only the ground vapor that intrusion that we're concerned with. It's the drinking water, and here again, they can say all they want that there are chemicals in our drinking water, but they're within safe levels for drinking water as outlined in New York State. However, keep this in mind. Anything above 0 is bad for you. And if you don't believe that, we get all our politicians all up and marching to the same tune here because you can't smoke. Secondhand smoke is bad for you. And even though they say you can go into a bar or a restaurant for a day or two and it won't bother you, but their whole premise is the people that work there are exposed to it every single day, so it's only a little over a long period. So the same thing should apply here with the PERC, the water, and everything else. Now,
They add up in a
what
way,
is
right?
the
There's a cumulative
long-term
effect.
exposure? What does that mean? Do I give you a massive dose today, or I give this gal over here just a little bit every day?
Yeah, yeah.
And where does that come out? So these are some of the things that we're looking for answers from, and
they're very hard to find scientists
You
who have
can't-
studied it, right?
well, this is a whole new avenue. There's no book you can open up right now.
That's right.
There just is no book. And as an activist group, likewise, there's no book that we can open up. The only history we've got is some environmental issues. Mm-hmm. But each one of them has their own specifics to follow and so forth. So while the scientists don't have an answer to it, we're not sure on the second hand who to push and how to get there. Mm. You're an attorney. I don't know where you practice.
I live, and my office is in Afton, New York, which is Shenango County. Sure. So I come into Binghamton for workers' comp cases, as well as Norwich and Oneonta.
We have probably 600 to 700 residents that have signed up with legal firms here. If you live around here, you heard this. It's died down a little bit now, but everybody was trying to get you to sign up as a client. And it's for a toxic tort. A lot of people thought it was a class action suit. It isn't. It's actually a toxic tort or mass toxic tort case. And there's two sides to it. One's the devaluation of property, which is a fairly straightforward, clean-cut, although it has its messy parts to it. And the other portion is the health. Health is...
And that's the messy portion, right?
This will last for, I don't have any idea how long. They say at least another 25, maybe 50 years. So I occasionally will call an attorney who is heading up all the groups, a consortium of legal firms, and they're all together now. There's 7 of them. And it's a fellow, he's the chief litigator for Levine, Gold, and Thompson, Phil Johnson. And we have tried to get information that to him, to the legal firms, that sometimes it's a little bit difficult for an attorney to ask for information or look around, because once they say I'm an attorney, people will shudder or they'll hold back. And likewise, he has done us some goodwill and judgment and some of the things that we're doing. And just recently, when I was going to write something for an article, I just wanted to run it by him. And I said, now, Phil, if I say this is not something that is going to get me in trouble. He says, not as long as you're not singling out a person. He says, Alan, don't worry about it. You're one of the few people I know of that has 125 lawyers behind you. There are 7 firms altogether. Mm-hmm. And right now they're doing their investigative end, or the investigative work, which is manyfold situation, much intricate, I guess, situation that will take them a long time. But they are working up to some sort of litigation, and I hate to say this, I can't tell you, but I think that we're going to get some good news here pretty soon.